Yesterday, Judge Lyman granted Blake Lively's motion to compel a subpoena that she had served on Skyline Agency, which is a Dallas based digital marketing and design firm that the Wayfarer parties engaged to create the website. The website being thelawsuitinfo.com. That's the website that came out in February of this year that had a slew of receipts, as people are calling them, and information in connection with Wayfarer's complaint against the Lively parties. It appears that the Skyline agency withheld production of this signal chat that included a number of individuals on it. The chief marketing officer, Abel, Nathan, Heath, another Wayfarer employee, Friedman, and some of the other attorneys at the Liner Friedman firm. Judd Wallace was on this group chat, signal chat, and some members of TAG, employees of TAG. Skyline objected to producing the signal chat because it claimed that the chat fell under attorney-client privilege and or common interest privilege. And the judge required an in-camera review of the chat, meaning that he required the entirety of these documents, the chat, to be produced to him in his chambers to review for the purpose of deciding whether or not the privilege applies. And upon his review, outlines in the order issued yesterday that neither attorney-client privilege nor common interest privilege apply to this specific text chain. This is going to be a really important lesson moving forward for anyone that thinks that they can say anything in the presence of an attorney and for that to be magically protected by attorney-client privilege. Just because there's a lawyer on your text thread doesn't mean that those messages are not discoverable. And that's something that everyone should be aware of in their day-to-day dealings and in dealings with an attorney. Essentially, the judge is saying here that these communications were not for the purpose of obtaining legal advice. If any legal advice was being sought, it was tangential and attenuated to the actual content of the conversations. The entirety of the conversation or the thrust of the conversation was not with the intention of seeking specific legal advice. And there was no client-attorney relationship between several of these parties. And common interest doesn't really cover it here, because common interest is where there's parties that have different attorneys and they have a common legal interest. I'll give you an example. Let's say we have employees that leave their employer, go to a competitor, and their former employer sues them for trade secret infringement. So they sue not only the employees that went to this competitor, but they also sued the company that they went to. So the employees that are being sued, though they work for the employer and can be indemnified for that employer, they might have separate counsel. So they will have their own attorneys, while the employer, so their company that they work for, would have their own attorneys. So they're still on the same side of the V in a sense, because the former employer is suing both the competition, the new employer, and the employees that work for the new employer. So they're on the same side of the V, but they're represented by separate counsel. And that's because there could be a situation in which these two have some kind of adverse situation against each other, and it's important to isolate them from the jump, have them have their own attorneys in case it gets to that point. However, leading up to that, with that hopefully not happening, these two entities, the individuals and the current employer, have a common interest in the litigation against the former employer who's suing both of them. So they would get into what we would call a common interest agreement. There would be a document that kind of outlines this, that says that we will share information between the parties so long as our positions don't become adverse to one of each other. And so that would then kind of, and it would encapsulate the two entities that are represented by different parties in a common interest privilege. But that didn't happen here. That's not really the situation here. And the judge is saying that's really what common interest is getting at. And that's not the situation here. In summary, the judge ordered those Signal chat messages to be handed over by tomorrow, September 5th. I doubt there's a smoking gun in this text thread. I think the text thread probably shows some loose language around the creation of the website. It might display some frustration by the parties in having to create the website. That would be my guess. I can't imagine that there's any smoking gun, really, and so we'll see. I guess we won't see because it won't necessarily be filed now. We might never see it, but if we do see it, it will be either a summary judgment or at trial.